I want to make it clear for the cameras that I'm still speaking as an ex officio member of the Planning and Zoning Commission. I'm here to argue on why we should consider keeping Appendix A in this plan. We came off of Pathways, and it's a tribute to your good work that the problems with Pathways have not repeated themselves. During Pathways, I think we had something like 1,300 people showed up in public hearings, hundreds testified. The comments against the plan ran something like 99.99% against. This plan, we had our public hearing, approximately 50 people in total showed up, I counted them, and 25 testified. And of the 25 that testified, a couple actually testified for the plan, and there were a total of 6 people who testified against the Appendix A. So what did they say? What are the people saying who are testifying against Appendix A? What are the words that they're using? Well, they're using words like unprecedented, nonsensical, property rights agenda, inappropriate, extremist, political, overreach, illegal. But the bottom line is these comments were overwhelmingly void of any meaningful content. But that raises an interesting question. Is Appendix A illegal? Well, if we look at the plan preparation section of the land use articles, it says the Planning and Zoning Commission shall consult with public officials. And if we are consulting with public officials, the implication is certainly that based on the input from these officials, it is appropriate to make changes or additions to the plan. So I suggest it is perfectly legal. HB 297 requires that we be consistent with our master plan. See, the state has consistently not been consistent with our master plan. They engage in lawless changes to our regulation using fiat processes that steal value from our farmers, steal value from our property owners. One example, SB 236, the septic bill. No due process, no just compensation is required under the United States Constitution, and out of nowhere we find our duly and appropriately adopted land use designations and zoning overlaid with a state-mandated set of tiers. Where was the state's concerns about making us inconsistent with our own master plan? Nowhere. They didn't care. But I submit that they were really pushing us in a direction that placed us inconsistent with our own master plan, and they denied our citizens any due process when they promulgated 236. Carroll County citizens have a right and a duty to be heard when these kinds of transgressions occur. We don't want this happening again. And we should, and we have a responsibility to hold the state responsible to adhere to its own laws. So let's take a quick look and brief excerpts, and let's decide whether these things are really extreme. Individual property ownership constitutes an asset of unique value and a foundation of individual liberty. This core value deserves priority consideration in all land use decision-making processes. Pretty extreme stuff. I don't think so. We believe a property owner is entitled to quiet enjoyment of their property, providing it does not unreasonably interfere with the ability of his neighbors to quietly enjoy their property. Does the state believe this? Some would say that it doesn't. We believe the exercise of eminent domain by government for the purposes of reselling to other private interests shall be deemed inconsistent with this master plan. Think it can't happen here in Carroll County? They've been trying to do it for the last several months in Montgomery County, our next door neighbor, buying a piece of land for $1.8 million and trying to resell it for $10. We believe Carroll County government should focus environmental protection and stewardship efforts on activities that will affordably improve the environment. The presumptive position of government is that the use of private property in accordance with applicable ordinances is not unduly harmful to the environment. Our presumptive position is that your lawful use of your property is not unduly harmful. Yet, the opposite is exactly what the rain tax presumes. The rain tax presumes that you're guilty until proven innocent. It presumes that water that coming off your property is polluted. It assumes that the water is leaving your property and getting into the bay, and it tries to tax or fee you when, in fact, there was no data. It takes the position that our citizens are guilty until proven innocent, whereas our system of laws requires that we assume innocence until proven guilty. We believe that except for prohibitions against producing illegal drugs, government shall not limit productive agricultural activities. Yet, we have a phosphorus management tool coming down that could jeopardize the financial viability of our farms. We believe that government representatives may not enter private property without the permission of the property owner or without a warrant, either judicial or administrative. But that's exactly what they're routinely doing right now, and we're no exception. We're going on private property, doing searches, sending out administrative complaints without having any due process for our property owners. And then the big one, most importantly, additional restrictions on land use by state, unless approved by the Board of Commissioners, shall be deemed inconsistent with this plan. Let me say that again. Additional restrictions on land use by the state, and I'm talking about mostly regulatory processes, unless approved by the Board of Commissioners, is deemed inconsistent with the plan, because we are the only ones accountable. The state regulators are not accountable to our citizens. They cannot fire them, but they can fire me. So it should require a Board of Commissioners adoption before these regulations from the state are allowed to infringe on our citizens' rights. Okay, let me summarize. So let's go back to the adjectives that were used. Is this letter illegal? No. Is it extremist? No. Is there overreach? No. I think it's clear that we are trying to limit state overreach. And what it does, simply stated, the primary role of this letter is to hold the state accountable to the same laws that we have to obey, because the state seems to think it's above the law, and most specifically HB 297. I want to point out that the entire Board of Commissioners supported this letter, and taking it out would not reflect the views and the wishes of the majority of Carroll County citizens. Thank you, Mr. Chairman.
Our role as a planning commission has not always been entirely respected as maybe as it should be.
Pretty extreme stuff. I don't think so.